Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupinda at Mississippi College School of Law, but I tell you that only for informational purposes. All interpretations here are my own and are not to be ascribed to my school. Now, what we've been doing, is my students in class are presenting their written position statements and making a 5-minute presentation in class. In that statement, they address a current First Amendment conflict, apply it to the law. They also must report on the opposite position to their own, and then they argue their own position, how they believe the issue should be decided based on the Constitution of the United States. We are having an exciting time. So today we had 7 position statements, and I'm going to summarize them for you here. Let me point out, my summaries are based on what I believed I heard them say and what I believe I read. So if I get some of them slightly off according to what the student's intent was, I know they will forgive me, right? I am not giving the students names to protect their own privacy. Now, let's start with the first one. The first student argued, Tennessee cannot kneel on expressive conduct or the right not to associate. Now, he's reporting on in the state of Tennessee, he reports that some legislatures are concerned that at some of the college basketball games, some of the players are taking a knee when the national anthem is played. And the student explains to us that some of these legislators say that they should pass a law where public funding would be denied to any university where basketball players take a knee during the national anthem. And he argues that such a law, such an action is unconstitutional. Now, as I pointed out, they also must address the opposite side. And he says that he realizes some people would say taking a knee is pure conduct. And for pure conduct, it's not protected under the First Amendment. Government may regulate pure conduct generally with a low level of review. He says that other people may argue that taking a knee is fighting words. And we know fighting words fall within an unprotected category that government may more freely regulate. But his position is that taking a knee during the playing of the national anthem is not pure conduct. He says it is expression. In First Amendment, we learned about expressive conduct and whether or not the speaker or the person intended to communicate a message and whether it was a message that others would reasonably understand. And he said here, it is. So therefore, it's a message and government can regulate it only if it meets a higher level of review. Now, he also uses the Texas versus Johnson case that we covered earlier this semester, where the court held that burning an American flag was protected speech. So he said, if that is protected speech, then surely taking a knee at a basketball game by a player during the playing of an anthem is also protected speech. Now, I didn't get to ask him all of my questions, but one of my questions had to do with, is there any relevance here to the Tinker case that we talked about earlier this semester. I know his position statement is about universities, it appears, but what about the Tinker case dealing with K through 12 speech? Is that also related to, or does it give some support to his position statement? All of the statements that we had today dealt to a degree with government speech, where government says this is our message that we want to convey. And here in this scenario, government is saying our message is you don't take a knee for the flag. And what about when that message conflicts with an individual's rights of expression or right to be associated or to not be associated with a particular idea? Here, the student says that there is a definite conflict here. And in his view, the individual's right to speak, their right to knee, their right to take a knee at the basketball games, the basketball players, that the government didn't have a right to kneel on their rights. So, very interesting statement. And I've given the full title to the statement in the text box below. And you can ask yourself, do you agree with the student or do you disagree, and why? Okay, let's go to the next one. The student argued, the Texas Lieutenant Governor, Dan Patrick's proposed Star-Spangled Banner Protection Act in response to the Dallas Mavericks owner Mark Cuban's decision not to play the national anthem before the first 13 games of the NBA season is clearly unconstitutional under the First and the 14th Amendments. So he reports that one of the teams, one of the NBA basketball teams, had decided they were not going to play the national anthem during their season, and that one of the state leaders had proposed a Star-Spangled Banner Protection Act, which said that the national anthem must be played at all events where they receive public funding. So this student argues that the Texas Lieutenant Governor's plan here is unconstitutional. He says it would be different if the NBA team itself, a privately owned team, decided they were going to play the anthem at the beginning of every game, that would be a private matter between them and their players in terms of how they would address that. He said, but here the state is attempting or considering this act that would force the team to require the playing of the anthem. And he believed that that is unconstitutional. He uses as his authority a case that we talked about earlier, West Virginia Board of Education versus Barnett. And that case from a long time ago, 1943, said that a public school could not force a student to salute the flag. And so here he argues likewise that the state cannot force a private individual, a private team, to play the national anthem at the beginning of every game. What do you think? Do you agree with this student or do you disagree? Let's go to the third one. Keep a record now of what you think. And they're all listed in the text box at the bottom of this video. Here is the third one. The government allowing certain depictions of art and not others does not infringe on First Amendment rights of expression. So her position statement was more specifically about the painting of murals on the walls and on buildings and what have you. And different people want to paint various murals as a form of artistic expression, or maybe just to beautify things, but also to communicate a particular message. And she reports that in some instances, the government is opposed to a mural. Maybe they don't think it's in keeping with the message they want for that given community, or maybe they disagree with the message, period, or they may not think the decor of it, the colors are right. So here she argues that in some instances, the government can infringe on a person's choice or tell a person they cannot paint a mural in that location. And in other instances, she says the government cannot. She used a number of factors in her analysis. I asked her some questions about how would she resolve different disputes. She said, well, is it on government property? Then maybe there's a leaning toward government being allowed in terms of its message, but government must still comply with the First Amendment. But if it's on private property, then there's even more respect to the private individual's choice of mural, be it a Starry Night mural or be it a Black Lives Matter mural. She believes on private property, then private rights ought to be preeminent. So what do you think? Do you think that the government can decide it doesn't like what you've painted on a wall? Do you think the government can extend that to private property? Do you agree with her statement that sometimes government can and sometimes it cannot? Or do you disagree? Okay, we had another one. This position statement was titled, "Officers should not be allowed to infringe on speech and association freedoms simply because they disagree with the content at peaceful protests." So her statement is about a situation that occurred, and there were allegations that during a peaceful protest, officers were physically aggressive toward individuals because they did not like their message. But others who had an opposite message, the officers did not take that aggressive stance toward them. So here she says that the officers must comply with the First Amendment. She says that if the government is allowing the protest, then the officers cannot choose to harm individuals from one group, but then allow the other group to engage in similar types of protests, similar types of actions. She said peaceful protesters should feel safe and protected, even if the police officers personally disagree with the messages they are articulating. She argues that in one location, they said, okay, you're tying up the traffic. So individuals who were protesting from one particular position, they were ticketed and charged. And someone who was opposite were not. So her view is, even if the officer is in disagreement with your peaceful protest about race or what have you, the officer still must treat the protesters with impartiality and respect their First Amendment rights. What do you think? Do you agree or do you disagree? Now, I had a question for her that we did not get to. And so the question related to content neutral, reasonable time, place, and manner regulations. Now, some of those regulations are not really content neutral. Government says, oh yeah, we stopped you because of your content, but we were concerned about the secondary effects. So my question, and I'm still trying to get it framed, but my question was, what if an officer is just unfamiliar with people who may be of a different color? The officer has not had exposure at all. And when the officer sees that individual, he sees, in his view or her view, secondary effects. He sees danger where there is none. How do we address that type of situation? How does that connect in with the First Amendment? And perhaps it connects in with both the First Amendment and the 14th Amendment Equal Protection Clause. Let's go to the next one. His statement was, the Equality Act destroys religious freedoms and associational rights. Now, his statement is about the Equality Act that from the House, that passed the House in February of this year. This Equality Act would add to, expand on the Civil Rights Act of 1964 to include, along with race, the sexual orientation and gender identity. So the proposed purpose of the Equality Act is to give additional protections for individuals who are LGBTQ. His position is that this act is not a good act in his view, and that it destroys religious freedoms and associational rights because it would inhibit the actions of individuals with certain religious perspectives. Now, there were some points he made in his presentation and position that were quite interesting. He said that he's not in opposition to the Bob Jones case. We talked about that case earlier, and it's mentioned in the text box below. In the Bob Jones case, Bob Jones University did not want to admit Black people to their school. And the court said, well, you're a private school, if that's what you want to do, but you will not get a tax break. You cannot get a tax break for engaging in that type of decision-making. Bob Jones School had said that this denial of people based on their race was in line with their religious beliefs. And the court said, you can do that, but you will not get a tax. You will not get tax breaks for doing that. Now, he says that the Equality Act while he agrees with the Bob Jones case, I believe, he finds the Equality Act to be different. He says that the Equality Act is dealing with a mutable characteristic. He says that gender identity or sexual orientation is a mutable characteristic, where he said that race was an immutable characteristic. So he saw a distinction in the two. So in addition, he says he's opposed to this Equality Act. He says maybe there's a different Equality Act that he might be in favor of, but he's opposed to this one because he said it is an unprecedented addition to civil rights and would place a burden on on individuals with certain religious beliefs. What do you think? What do you think about the Equality Act? Do you agree with him or do you disagree? Okay, we have a couple more. Her position statement is this: the problem of religion wrongly asserting protections leads to violations of the Establishment Clause of the First Amendment. Now, in her position statement, she refers to a number of laws and legislative attempts and laws that were passed, for example, in Mississippi, whether it was dealing with abortion or other matters. And she says that while religion by itself is not a bad thing, she says that religion fits within the private sphere. And when government starts to make religious proclamations or laws based in religion in the public sphere, she said, then there is a problem. And looking at her competing positions, she said, of course, religion aids in the development of morals that may guide many citizens. But her position is religion should not be able to assert protections granted to those who operate in the private sphere. So when government starts to step into when government starts to use religion, not just in terms of encouraging it in a private context, but making it a part of the public law, her argument is that is impermissible under the Constitution. Now, I didn't get to ask her, but when we covered the Establishment Clause earlier, we talked about various tests. One test was the Lemon test. The Lemon test, the first prong was whether or not the law had a secular purpose. If the law only had a religious purpose, then the court had deemed it to be unconstitutional. So her argument, it appears that she is arguing for a continuation of the Lemon test, and that the first prong of the Lemon test ought to be applied, in her view, perhaps in a stricter way. She says a way to remedy this is for a strict secular requirement before government can pass laws. That government should not be passing laws where the whole purpose rests in some variation or certain expressions of religious beliefs. What do you think? Do you agree with her or do you disagree? Okay, here's our final one. And let me just look through to make sure I've covered all 7. I believe I have. Let's look through. And here is the final one. He argued state mandated license plates should not include religious expressions. So you see, the students have been thinking a lot about current conflicts and current events, not just in Mississippi, where our law school is, but all over the country. And his statement is no exception to that. He's looking at recently, well, it's been a couple of years ago, the Mississippi license plate added the term "In God We Trust." It's on the license plate for Mississippi. And the Mississippi flag, we recently changed the flag, but it added on the flag, "In God We Trust." That was mandated that it must be on the design by government. So in his position statement, he is looking at the Mississippi license plate, and it includes "In God We Trust." His position is that is in violation of the court's holdings in the Barnett case going all the way back to 1943, and also the Woolley case from 1977. In Woolley, a Jehovah's Witness taped over the message on the license plate that said "Live free or die," and said that it was counter to their beliefs, to their religious, their moral, their ethical beliefs. So here he's saying that the state should not have added that phrase to a flag, to the license plate. Now, he argues both sides. Some people would say, "Oh, it's just a license plate. It's not making you say it." But in Woolley, the court said it was making the person say it or to be associated with that idea. So in his position, he comes up, well, in his conclusion, he comes up with an alternative. He says, okay, let's say Mississippi wants that on the tag. He believes the state should also provide an alternative tag without the words "In God We Trust." He also pointed out that some people would say, well, just go buy yourself a vanity tag that can say something else. But his argument is that an individual who does not want that religious expression on their tag should not have to pay extra for a vanity tag. And that if the state wants to communicate that message, then it must provide an alternative for individuals at no additional cost. What do you think? Do you agree with him, or do you disagree? We are having such an amazing time with these position statements, where the students are analyzing a current First Amendment conflict, looking at the relevant law, arguing the other side, and arguing their own side. In addition, they do a presentation in class, and their classmates get to ask them some questions. And if we don't run out of time, I also have lots of questions I want to ask. They're all doing exceptional work. Now, as I told them in class, just because I say their work is exceptional does not mean I agree with everything they say. But that is not my goal as their teacher. My goal is to help them learn to analyze an issue, looking at various perspectives, apply the law, stand in their position, and be open to the agreement and the disagreement of others. Look, it's all about learning. And learning is a key. Learning is a pathway to enlightenment, and enlightenment to freedom. And I do hope that freedom takes us on the pathway to justice, or at least to a taste of justice. So tune in next time, and I'm going to tell you about the final 7 presentations in the class. You take care. Bye.